SIAC or SIAC arbitration. And we do see in my line of work, and even previously when I was at SIAC, we do see so many parties coming from, let's say one party is from Vietnam, another party is from the Philippines, and yet they choose to have their arbitrations conducted in Singapore because of a number of factors, which I will go into. So my job today is just to describe to you what arbitration would be like if you're doing it in Singapore. I will start with a few basics in Singapore arbitration. And because a lot of these contracts also prescribe SIAC or SIAC arbitration to the extent that the SIAC rules or the SIAC procedures are applicable, then I will also go into that in more detail. So first we have, why is Singapore arbitration so attractive or appealing to a number of parties, and not just in Asia, but we get a lot of SIAC arbitration from parties in the US, from Europe, from Africa. We do get that a lot. And I've listed in the slide a number of reasons for this. So first, Singapore does have that reputation for independence. It has a perception of low corruption level. Language fluency is great. Everybody speaks English. And so a lot of foreign parties feel comfortable with that. And there's very good connectivity. The Singapore International Arbitration Act, which is basically the arbitration act which governs all international arbitrations, is also based on the ancestral model law, similar to the Philippines. It's a party to the New York Convention, which, as Rebecca discussed earlier, means that the award issued there can be enforced in over 150 countries in all the signatory parties to the New York Convention. There's a strong tradition of the rule of law. So a lot of parties feel very, very confident that whether it's a case before the court or they have an arbitration but there are court-related proceedings, or in general, they have a very strong confidence in the rule of law, and that whatever procedures or regulations are prescribed will actually be followed. There's also a highly skilled judiciary, or they advertise we have a highly skilled judiciary, and more importantly, they have a very good non-interventionist approach with judicial support for arbitration. What this means is, for example, the courts are very much supportive of when two parties to a contract have an arbitration agreement. So, for example, Party A has a contract with Party B, there's an arbitration agreement, Party B decides, you know what, I don't care, I'm going to file with the court. The court will take a look at the contract, and if they see that there's actually an arbitration agreement, more likely than not, the court will stay those proceedings. In other words, they'll suspend those proceedings and tell the parties, no, you have to go to arbitration. That's the general rule. Parties have freedom of choice of counsel. What this means is that you can actually choose anybody to be your counsel. And to be frank, you don't actually need lawyers to be a party to an arbitration. It's just that in these days, a lot of arbitrations are very, very complex. So most people, most companies feel more comfortable hiring outside counsel. That being said, one of the questions that we usually get is, do you have to be Singaporean or Singapore qualified to be an arbitration counsel in Singapore? And the answer is no. For example, I'm not Singapore qualified, but someone like me, qualified in the Philippines, others, is allowed to practice arbitration in Singapore. The government has made sure of that they allow foreign practitioners to come into Singapore and practice international arbitration. And that ties into the next bullet point, which says non-residents do not require work permits to carry out arbitration services in Singapore. So usually when you're working in Singapore or any other country, you would be required to get an employment pass or a work permit, but for arbitration, there's a specific exception to that. And this is also in line with the Singapore government's push to have Singapore as a hub of international arbitration in Asia. And there are a lot of facilities that support the conduct of arbitration. For example, one of the government-funded projects quite a while back was the development and building of Maxwell Chambers. Maxwell Chambers is actually a hearing center. It's an integrated facility for hearings where all of your they have dedicated rooms just for hearings. You don't have to set it up. They're extremely well qualified to conduct your hearing. So essentially you just book a room and they'll take care of the rest for you. And lastly, third-party funding is allowed in the field of international arbitration and other related proceedings. So for those who may not be very familiar, third-party funding is a situation where you have a claimant in an arbitration. They want to file a claim, but perhaps they don't have enough finances, or they're not liquid enough to fund the entire process of arbitration. What they do is that they can look to what is called a third-party funder, and third-party funders are essentially investors who look at potential disputes or potential claims, and then they will fund they will fund your filing of the case, hiring of lawyers, and then of course there's a separate third-party funding contract for this, where they do get some sort of income at the end, either a certain percentage of the award or a certain percentage of any settlement proceedings. But the point to note here is that third-party funding, which is something that is not allowed in many countries, especially common law countries, is allowed or has recently been allowed in Singapore because, again, Singapore wanted to encourage international arbitration. So the next slide is essentially a photo of Maxwell Chambers, which I was mentioning before. On the right is a sample of one of their rooms for large arbitrations. So again, for those who are not very familiar or who haven't attended an arbitration hearing before, this is typically what an arbitration hearing would look like. You have at the left side of the photo, 3-member arbitral tribunals sitting together. Maybe on one side of the long table are the claimants, counsels. On the left, on the other side are the respondents, their lawyers. Usually the witnesses sit at the little middle table, little table in the middle, and that's also either you have fact witnesses or you have expert witnesses. Now I'm just going to do a side discussion on SIAC and SICC. And the reason I'm doing this is because I know that sometimes there are many clients who've had a little bit of confusion as to what the differences between these two acronyms are. So SIAC is a Singapore International Arbitration Center. It's an independent arbitration center that I mentioned before. It's the only local arbitration center in Singapore. They administer arbitration cases, sometimes also ad hoc cases. They don't administer it, but they take it in whenever the parties need somebody to appoint the arbitrator. And in order to have your case administered by the SIAC, your arbitration clause, which Rebecca discussed earlier, must actually specifically refer to an arbitration to be conducted by the SIAC under the SICC rules. On the other hand, if you look at the right side of your screen, we are talking about SICC. This is actually the Singapore International Commercial Courts. Now, it's not an arbitration center. It was created only in 2015. What it is it's a separate branch of the Singapore court judicial system, and it's designed specifically to deal with transnational commercial disputes. So your case can be heard by the SICC if it falls under, if it complies with these 3 categories. So for example, the claim must be of an international and commercial nature. They must have submitted to the SICC's jurisdiction, and they don't seek any relief in the form of a prerogative order. Oftentimes, sometimes when you file a case in court, when the court looks at it and understands that it is an international commercial dispute, they can actually also refer it to the SICC. And why did they have to create this special body? The reason is that they wanted a body within the judicial system which can deal with commercial cross-border disputes and still have some of the advantages that arbitration has. So I think as mentioned by Rebecca earlier, under arbitration, you have the procedure, confidentiality, flexible procedures. So for SICC, they also have confidentiality provisions which the parties can avail of. So they're trying to have a hybrid form between a court system where everything is public records, and then arbitration where everything is confidential. So, but the beauty of it, because what they're trying to do is that when you have a court case and then you do get a decision, then you get you have that in public record that you have a decision against you, as opposed to arbitration, where generally, as I mentioned, it's confidential in nature. So that's the main differences between the SIAC and the SICC. When you have an arbitration, and it says SIAC, it will go to the left side of your screen, to the arbitration center. Now, before I move on further to the rest of my slides, and I'm just going to show you an overview of the common stages in an international arbitration. And this is more for those who may not be very familiar yet with the stages, or what exactly happens in an international arbitration. How is it different from court procedures? And I know Rebecca already touched on this earlier. So what I will do in this slide is to discuss these stages in relation specifically to the SIAC procedures. So first you have the commencement of the case, right? When you have a dispute you want to file against somebody else, what you do is you file a notice of arbitration. Most of this, the details of this will be in the SIAC rules, and again, I'll go into these a little bit later. Then you have the appointment of the tribunal, the person who is supposed to decide your case. Again, as Rebecca mentioned, they don't have to be lawyers. They don't have to be any particular nationality. Frankly, they can be anyone. But if you have a dispute and you have an IT dispute, you want somebody knowledgeable about your subject matter. I have seen many cases where parties decide to select an arbitrator because he's very famous or he's very well-renowned and well-respected in the community. But if you have a very technical dispute and your arbitrator doesn't really know that much about it, you will spend a long time or a significant amount of time in your hearing, in your pleadings, trying to educate essentially the arbitrator. So most of the time, you want the arbitrator to be quite knowledgeable already. After the appointment of the tribunal, most of the time the tribunal will set a timetable for the rest of the proceedings. And this timetable will include the submission of pleadings, how many pleadings, how long in between, do you allow amendments, is there a discovery phase? And then sometimes when the situation calls for it, you have submissions of expert reports. This is not common for all cases, but I would gather that for most IT disputes, if the dispute is of a very, very technical matter, you require specialist knowledge. Most of the time, parties want to submit expert reports so as to, as part of their evidence in supporting their claims. After that, you have the evidentiary hearing. Just like submission of expert reports, hearings are actually optional. Sometimes if the dispute is very small and then the issues are actually very simple, you don't need an evidentiary hearing. You can ask, if both parties agree, they can say to the tribunal, hey, why don't you just decide this dispute based on all the documents before you? So that's usually called the documents only arbitration. And that happens quite often for very small disputes. Lastly, after you have the hearing, sometimes you have post-closing submissions, which is pleadings based on everything that has transpired, including the hearing. And then you have the award. Once you get the award, then that, it's not the end of your dispute. You still have to enforce it unless the other side decides, I'll just pay this voluntarily. So like I said, I'll just go down a little bit to the nitty-gritty. So once you have a dispute, you've chosen SIAC arbitration, and then you decide, okay, I want to commence my arbitration. I do want to file against the other party. What you have to remember is you have to file the notice of arbitration, you have to pay the filing fees, and then you have to already start thinking about who do I want as my tribunal members. Notice of arbitration isn't very complicated. If you look at the SIC rules, there are certain things that it must contain. For example, the names of the parties, the nature of the dispute, but it doesn't require you to provide a full-blown statement of the claim, although you can choose to do so. It's not required. Payment, as if I recall correctly, the current payment filing fee for the SIAC arbitration is 2,000 Singapore dollars. And usually you have to file this together with your notice of arbitration, or else your notice or your case is not deemed commenced. And the date of commencement is usually very important because a lot of timelines are pegged to that date of commencement. So as I mentioned, when you commence a case, you have to file a notice. And in the third bullet point, you will see some of the requirements that the notice of arbitration must contain. Again, it's very simple. You can actually compile this together if you're, let's say, you have a deadline wherein you need to file, you have a statute of limitations issue, and you need to file by a certain date. These are actually quite easy to comply with. So you need to demand the dispute be referred to arbitration. You have the contact details of the parties, a statement of the arbitration agreement, a description of the dispute, a nomination of the arbitrator, comments on other procedural matters. For example, what is the language of the arbitration? Is it in English? And as I mentioned, the applicable filing fee. So as to timing, when should you start filing your notice of arbitration? And so there's really no specific timing under the SIAC rules, but as I mentioned, you have to be aware of any timings under your contract. So for example, there are some contracts which contain very, very extensive reps and warranties. And sometimes I've seen contracts and I've had disputes where the warranties are under a time limitation. For example, your contract can say, okay, this is a warranty of ABC, and then in a separate annex, it will say something like, all warranties must be claimed within 2 years as of the closing date. So you have to be aware of that. So let's say you're in your last month before 2 years expires, then you really have to make the decision, do you file or not? Because otherwise your right to file an arbitration case could expire under your contract. In terms of content, like I said, it does not require very extensive submissions. And if you recall, I mentioned in the last slide that you have to nominate your arbitrator. If you don't, that's fine. Well, it is preferable that you do, but under the SIAC rules, if the parties do not nominate an arbitrator, the SIAC will nominate one for you. And in order to do this, what they will take into account is the content of your dispute, which is why the description of your dispute is important. They must understand, for example, okay, this is an IT dispute relating to maybe intellectual property, so that they'll be able to get somebody who is knowledgeable in that field, who has had experience maybe in IP or IT, and they will also take into account the quantum of the claim. So the quantum of the claim, meaning how much are you claiming for? Is it $2.5 million? And you don't have to quantify it at the beginning, although it's better if you do, but eventually you will have to quantify it at a certain point. One of the features of SIAC arbitration is that it has the possibility for consolidation of contracts, consolidation of arbitrations. So if, for example, you have multiple contracts all related to each other, it has provisions where you can file one arbitration in respect of several different contracts, as long as you comply with the requirements under the SIAC rules. This slide is about the selection of arbitrators. And I think, as Rebecca touched on, it is a very, very important aspect, because this is really what sometimes can make or break the case, because this is the person who will decide the dispute. They will decide who is entitled to what in terms of claims and defenses. So you do want somebody knowledgeable, at the very least, of arbitration, of the subject matter. So first, for example, you have to check the agreed procedure. In some more complex contracts, it already provides for a procedure to select the arbitrators. For example, we have seen certain contracts which state all disputes must go into arbitration. There must be 3 arbitrators, and no arbitrator can be of the same nationality as any of the parties. So you have to bear that in mind. Under SEAC rules, there's an expedited procedure available wherein the arbitration is compressed to 6 months. In that situation, even if your contract provides for 3 arbitrators, you can only have 1 arbitrator. So that's why I said here, you have to note this particular rule. Second, you have to check on your arbitrator's independence and impartiality. This is extremely important because, as Rebecca said, your arbitrator is not your lawyer. He or she or they are not your advocate. It's not their job to fight for you. Instead, they actually have to be very independent and impartial. Then, of course, you check their background, qualifications, seniority, experience, and familiarity with the industry. And language abilities is also often important. Familiarity with the jurisdiction, and availability. A lot of very senior arbitrators, you actually have a very difficult time pinning down their schedule. So you may get them as an arbitrator, but your timetable, which I mentioned earlier, can stretch to quite a long time if they are jam-packed with hearings, which means your own hearing may take 1 year, 2 years after. And the usual timeline of a medium-sized arbitration is about 1.2 years. So if you have your arbitration hearing beyond that, then it necessarily extends your timeline as well. And rates. In arbitration, because it's a private procedure, you do pay your arbitrator's fees. Most of the time, the more senior arbitrator is, the more expensive they are by the hour, and you do have to pay them by the hour. If you have a SEAC arbitration, it's different because they calculate arbitrators' fees on an ad valorem basis, which means they look at the quantum of your claim. As I mentioned earlier, at some point you have to quantify your claim, and then they apply a formula wherein they can calculate the amount of arbitrators' fees. Of course, this does not prevent the parties from agreeing that we want to pay the arbitrator on an hourly rate. Maybe for them it's more economical, maybe for them it makes more sense. I've seen arbitrations where the arbitrator himself requested for him to be paid on hourly rates, and if the parties agree, then that is what will happen. So again, choosing your tribunal, this is a reiteration of what I've said earlier. For procedures, so if you recall the chart earlier, after you choose the arbitrator, most of the time he will then set out a schedule of the proceedings or a timetable. And you have generally, you have the statement of claim, you have the statement of defense. Most parties will want another round of submissions, maybe a statement of reply, a statement of rejoinder. And the timetable for this is determined by the tribunal, or it can also be agreed upon by the parties. You also have the pleadings versus memorial approach. And there are 2 very different approaches in terms of making submissions. On the pleading side, you have written submissions, meaning I have my statement of claim here. Later on in the proceeding, I will submit my factual witness statements. At a certain time in the proceeding, maybe I will submit my expert reports. In the memorial approach, it's more common in common law countries, everything is submitted all together. So you have your pleading, which is, let's say, your statement of claim. You already attach all the factual witnesses that you have, or factual witness statements, affidavits, and then you also attach, if you're using them, all your expert reports, basically all at the same time. And then same goes with the other side. They submit their statement of defense. They attach everything that they have in support of that statement of defense. So how this is done is, again, because of party autonomy, the parties can agree which kind they want. Most of the time, if the parties cannot agree, the tribunal will make a decision as to which one will be followed. So I'm going now into the next icon, which is the conduct of the hearing. As I mentioned, you don't necessarily have to have a hearing. In some disputes, smaller disputes, the parties decide that we can just go on documents only hearing. And this is usually for simpler issues. And it really saves a lot of costs for the parties, because you don't need to conduct maybe 3, 4, or 5-day hearings, paying for your lawyers, your arbitrators, and your experts' time. So if you're confident that a lot of your issues can be decided just based on the pleadings already, then it is something that you can also opt for. So on the other hand, if you do decide to conduct a hearing, there are certain things that you have to bear in mind. So first, you have the list of issues. You want to narrow down as much as possible what kind of issues will be talked about during the hearing, so that you don't stray, you don't waste anybody's time, because again, you're paying everybody for their time during the hearing. You have a hearing timetable and allocation. So for example, I am the counsel for the claimant, and then somebody is the counsel for the respondent. We already agreed I will have maybe 40 minutes for my opening statement. The other side has equally 40 minutes. We can agree that I have half a day to cross-examine their witness. They can have half a day to cross-examine my witness. So all of these can be agreed upon before the hearing even begins, so that it's very, very efficient. You can also agree on the order of witnesses, and I can decide, I feel that strategically, witness A is better to, he's my strongest witness, I want to put him up first, or whatever reason. You may have different strategic reasons for presenting your witnesses in a certain way. And then, of course, as I mentioned, you do have cross and redirect examination. You can present additional evidence. Sequestration of witnesses usually occurs when you have multiple witnesses, and you don't want witnesses number 2 and 3 to hear what number 1 is saying until after, you don't want them inside the room essentially until after their turn being cross-examined is over. So again, usually the parties would agree on this rule, and it's a very common thing to have in large arbitrations as well. Attendance of party representatives is important because, again, everything can be agreed upon. So you can actually say, we object to party A being in the room, or and you have to give good reasons for this. You can have demonstrative exhibits, which is you not just your documents. You can present it maybe in a PowerPoint. You can bring items. Again, very, very flexible in terms of arbitration. So if you have an IT dispute that you feel is better served, your case is better served by actually demonstrating maybe a certain capability or a certain function than describing it on paper, then you can definitely do that in an arbitration hearing. And transparency. So everything is disclosed to both parties. You can't, for example, the tribunal usually doesn't write to one party ex parte. He has to write to both. Everything is very transparent among the parties and the tribunal. In terms of logistics, I will just go through this very quickly. You have to find a venue. So again, in Singapore, the most popular venue is Maxwell Chambers. You're not required, however, to go to Maxwell Chambers because you can still find other alternative venues. For example, in smaller cases, we've actually held arbitrations in maybe the arbitrator's office if he has a large enough conference room, or we've also volunteered our own conference rooms if the parties agree to it. So there are very different kinds of permutations to this. Usually you prepare hearing bundles, so during the hearing it's very easy to refer to all of your exhibits. You have transcribers, so just like in court where you have stenographers, in arbitration you have transcribers that you hire. Again, usually the charges are per day, and they can provide you with a transcript of the notes either live, which means it's projected on the screen while you're speaking. And this is very, very good if, for example, the witness says something, nobody heard it or you didn't hear it, and you're the one cross-examining. You can just refer back to the notes then and there. You can have it same day, which means at the end of the hearing day, maybe at 5 p.m. or 6 p.m., you can have sometime after that, a few hours, depending on your provider, you can already have a copy of the hearing transcript to review before your next hearing day. And next day is just that. You'll usually get it, the next morning from the day of the hearing. Translators, sometimes it's required when you have foreign, other witnesses who don't speak whatever is the language of the arbitration. The most common language of the arbitration is English, which means all proceedings are conducted in English. But there are many times when your witnesses may be from different countries and they don't speak English, so you can hire a translator. And again, being very transparent with all the parties, inform everybody that you're hiring this translator to help assist with the witness. Recording is something that is not very common. Should you decide to record your arbitration here, you of course have to get the consent of everybody, but it's not always very common. And accommodation. So if you have witnesses, parties, lawyers, arbitrators flying in from different countries just to have the physical hearing, then most of the time there are costs associated with that. And unfortunately, they will be borne by the parties. So it's something to bear in mind when you have arbitrations involving different parties from different countries. So one of the things that I've noticed now because of COVID-19 is that we're starting more and more to have a lot of virtual hearings. So you don't necessarily have to fly to a place in order to conduct your arbitration hearing, in order to have a cross-examination. Instead, it's done virtually, sometimes by Zoom, sometimes by other applications such as Blue Jeans. And if I'm not mistaken, it's something, virtual hearings or online hearings is something that will be discussed in a later webinar in this Digital Transformation Thursday series. So we'll talk about that during that webinar. So next slide is I think the left picture is, I've shown you earlier, a sample hearing room in Maxwell Chambers. On the right is what it looks like. So you have the tribunal at the end, and then somebody's presenting, counsels of one party to one side, the other counsels to the other side. Usually everybody brings their laptops or their computers, your documents, your pleadings, and all your evidence. So it's usually like that. It's very different from a court setting, but it's also a lot easier to refer to your documents, and it's private. So nobody else can enter the room except those involved in that particular hearing. So now we go into the award. After the hearing, maybe there are closing submissions, which is more written submissions to the tribunal. And then at some point, you have the tribunal issues the award, essentially deciding the dispute. Now, there are different kinds of awards. You have interim awards, partial awards, final awards. And if you look here, there's a consent award. This is in case of party settlement. What happens is if party A and party B in the middle of the dispute, they decide that, well, okay, you know what, we don't actually need to go through with this entire thing. Instead, we will just settle everything, and they have a settlement agreement. They can inform the tribunal if they want a consent award, and the tribunal will transform that settlement agreement into an award. And the reason parties want to do that is because they want the enforceability of that award. if you recall, as I mentioned, awards are enforceable in almost all countries, in at least 150 countries. So if you have your settlement agreement contained in an award, then you can enforce it if ever anybody breaches that settlement agreement. For post-award remedies, what happens? What do you do if you lose? What do you do if you think that there was some injustice done to you? Or maybe more importantly, what do you do if somebody filed a case against you and you were actually never informed about it? You never knew, and then all of a sudden the tribunal issues an award against you and you just find out long after that there was an award against being enforced already against you. So the general rule is that there's no appeal process in arbitration. That's general. Of course, it still admits of some exceptions. And when you have an award, you also have the option to challenge the award, or you can set aside the award, or you can maybe just settle with the other party. I've seen cases where an award had been issued against the respondent, and maybe for whatever reason they decide, you know what, we will just settle this because maybe they have an ongoing business relationship that they don't want to damage. And I mentioned earlier about setting aside. So what I'll discuss here is how to set aside in Singapore, or at least what are the grounds for it. So under the model law, the UNCITRAL model law, there are certain grounds for setting aside an award. This includes, for example, where a party was under some incapacity, they weren't, generally your contract rules for invalidating a contract applies. If there was no proper notice of the appointment of the arbitrator or the proceedings, or the party was otherwise unable to present his case. So this is what I mentioned earlier, that we've seen arbitrations where the respondent never appeared, but because in arbitration, you just have to prove that you've sent sufficient notice, it's possible for the arbitration to still proceed. So, again, it depends so much on the circumstances of the case, but there are instances where that respondent who was never informed properly can actually file to set aside the award based on he was never made aware of the arbitration proceedings in the first place. Third is when the arbitration or award deals with a dispute outside the scope of the submission, or contains, it's a dispute. The dispute itself is outside the submission to arbitration. So sometimes you see contracts which state all disputes except maybe warranty claims are subject to arbitration. So if you file an arbitration based on the warranty claim, you can challenge this and say this was outside of the submission, outside the scope of the submission to arbitration. Or there are times when the arbitrator makes a decision on the arbitration beyond what is the actual dispute. So the parties may say, we are only arguing, or we are only disputing on issues 1, 2, and 3. But when the decision or the award comes out, the tribunal actually decides on 1, 2, 3, and he makes another decision on 4. So that's another ground to set aside the award. The next bullet point is composition of the tribunal, or the procedure was not in accordance with the agreement of the parties. So this is why I mentioned earlier, you have to look at the contract. What does it state? If it says that specifically maybe that one of the arbitrators must be an engineer, and you constitute a tribunal where nobody's an engineer, or any other violation of the procedure laid down by the parties, it's a ground to set aside the award. The next one is subject matter of the dispute is not capable of settlement by arbitration. So, for example, in some countries, employment disputes cannot be subject to arbitration. Patent disputes, it really depends on the law of the country under which the arbitration is subject to. And lastly, if the award is in conflict with the public policy of the state, this state refers to Singapore in this particular case. Of course, it could refer to different countries depending on which arbitral law you're looking at. But examples of public policy is for maybe if the arbitrator was actually biased, for example. So that's not a specific ground under all of these, but we have seen cases where the parties try to argue that the arbitrator is biased. Maybe he used to come from the same law firm as one of the parties, and he never disclosed it. The important point is he never disclosed it. And you can say that this affected the arbitration. I was not granted the right to fairly present my case, and sometimes it's an argument that wins, sometimes it doesn't. But these are the kinds of arguments which can fall under public policy. Under the International Arbitration Act of Singapore, they add 2 more grounds. First is that the making of the award was induced by fraud or corruption, so you paid somebody off, or there was any dishonesty in the making of the award, or a breach of the rules of natural justice occurred in connection with the making of the award by which the rights of any party have been prejudiced. So these are the kinds of setting aside grounds in Singapore that you can find. So in this last slides, I will just discuss with you what are the things that you should consider when you're actually faced with an IT dispute. So I'll try to tackle everything that we've discussed in this webinar so far, the points Rebecca raised, the points I've raised earlier in this portion. So you have to know your options and you have to align your objectives with your assessment of the case. So first you look at how strong is your case. Do you actually have the facts to buttress your case? How strong is your counterparty's case? If you feel that your case is not really very strong, do you want to look at mediation maybe? Do you want to look at settlement instead? If you feel that your other party's case is actually very weak, do you want to look at summary or early dismissal procedures? What are the potential claims and counterclaims? So it's something that you have to look into in advance. Do you have sufficient evidence available? So early in this webinar, JJ was saying that proper contract management includes making sure that you document everything and retain all these records in the event of a dispute. And this is completely right. Like, you have to make sure that you know the extent of the evidence available. Because the last thing you want is you're halfway through the arbitration, you're almost at the hearing, you've spent a lot of money, and then you realize your key pieces of evidence are actually not available. So this is also where you decide, do you need an oral hearing? Can you do documents only? Can you do discovery? And usually in arbitration, discovery is actually very popular to, in a sense, extract evidence from the other side that exists. Are there any applicable investment treaty or protections? So this is a separate topic, but it was also discussed by Rebecca as to treaty arbitrations. Is there an applicable BIT? Is this even a covered investment? And where are the counterparty's assets? So as I mentioned, even if you get an award and you win, that's not the end of the story. You actually have to enforce it. You actually have to be able to get the money, get whatever it is that you prayed for and you were awarded. So you have to think first, even before you start a case, does the other side actually have the money to pay you? Or are you just sinking money into a long arbitration hearing, and at the end of the day, they'll turn out to be insolvent? Are they, check if they're sufficient? Should you settle? What are the courts like in the places where the counterparty's assets are located? And are there any recognition and enforcement arrangements? Check also whether there are other forms of protection, such as performance bonds, that you can just draw upon instead of going into arbitration. And check whether there are any timing issues. Is there a statute of limitations for your claim? Is there a contractual bar to your claim? As I mentioned earlier, some timing issues, they're very important, otherwise your claim can be struck out. So, of course, you have to check what is your overall goal. Is your goal achievable? Is there a continuing business relationship? If party A and party B actually have several ongoing contracts, how feasible is it to file an arbitration against them? Should you then just maybe look at negotiation or mediation instead? Will it ruin the business relationship? What is your appetite to fight the case? Because in arbitration, most of the time, it's a lot faster, more efficient than litigation, but you still have to dedicate a lot of resources into it. You have to dedicate funds, not just to pay your external counsel if you're hiring one. You also have to dedicate manpower within your team to talk with the lawyers, to streamline the evidence, to collect the evidence and gather them for you. So there's a lot of investment here that is being made. So you have to assess personally, how much are you willing to fight the case? Do you have sufficient resources? Can you consider third-party funding, which I mentioned earlier? Is there insurance? And then you check, well, how about the counterparty? Do they have enough money for this as well? And you may want to check, is there a reputational or PR risk? If you're a very big company, there may be certain implications as to, the news getting out that you're actually filing a case against maybe one of your suppliers. And as much as arbitration is confidential, sometimes the parties themselves, and you can't really pinpoint who, will leak it to the media. So if you have those kinds of considerations, then that's something to think about. And are there any urgent circumstances? So in arbitration, you can also have what we call interim measures from the court. And this means that you can get maybe a protection order, an injunction, garnishing of assets, things like these to preserve the assets prior to you actually commencing your case. Or another option is under the SEAC rules, they have a procedure called emergency arbitrator procedures. In other words, an EA procedure. And this is something that was instituted so that parties, usually the claimant, can get rapid relief against the other party without having to wait for the period of appointment of tribunal. So this is very fast. And for example, you sold goods to the other side won't accept your goods. And your goods, for example, are perishable. So you can file an arbitration about that, but in the meantime, your goods are going to, they're going to perish. So you do need some interim relief, and that's something you can get either from the courts or you can get it from the emergency arbitrator. So that really completes my presentation for today. And if you have any further questions, again, feel free. And I think there's a number of questions in the Q&A box right now. Just feel free to raise them and we will do our best to answer.